We do use it for intake, making sure that we get the details that we need to have, making sure that clients, or excuse me, when the clients call, the phones are answered and they'll just keep ringing. So AI has been helpful there. We've used it in document review, a closed loop system where you can try to make sure you're hitting what we need to hit when we're reviewing medical records. Um, we're looking at different platforms about chronologies and, consistent communications with client. We already do that, use AI for that. So every month there's something that's going out. Even if the client hadn't called in 6 months, they're getting an update. There's some lawyers out there doing some really interesting stuff on focus groups, and we've used AI to really focus group some cases in a unique way. And it's been pretty accurate. It's been really helpful for us. And so that kind of gives us an idea of what a likely juror is to think about. And it's weird to say that it's been accurate, but in hindsight and in doing real live focus groups, AI, if you do it right, you prompt it right, you get some real insights there.
Hello, everyone. Welcome to the PI Playbook podcast, a show where we get inside the huddle with successful personal injury law firms and lawyers and discuss what's made them successful and where they see their firm moving forward. I'm really excited about today's conversation. I'm joined with Erik Heninger of Heninger Garrison Davis in Birmingham, Alabama. Erik, thanks for joining us today.
Glad to be here, Adam.
So, as a brief introduction, Erik's story in law literally began at the dinner table with his father, Steve, the founding partner of his law firm, sharing stories of clients and the power of advocacy. That foundation turned into a career where Erik now represents plaintiffs in some of the most complex catastrophic injury cases across Alabama, Mississippi, and Georgia, including trucking collisions, medical negligence, and sexual abuse litigation. He's the past president of the Alabama Association of Justice, serves on the Alabama State Bar Board of Commissioners, and is a frequent national speaker with the American Association of Justice, where he teaches trial advocacy to attorneys across the country. Erik, thanks again for joining us on the show today.
Absolutely. Looking forward to it.
Yeah. So let's kind of start with the firm, HGD. The firm was founded in 2006 as what you guys call a pure trial firm. And that phrase stands out to me. When you and your father and the founding partners came together, what was the intentionality behind putting HGD as a trial-first culture versus a broader litigation practice?
Well, I think it was born out of necessity. What we were seeing in the legal environment is even more true today. If you look across the legal landscape, you're seeing that the real results and the best results for the clients are usually obtained in trial. And at the very least, if you're not willing to go to trial, it's unlikely that you're going to be able to obtain the best results for the clients. And so when I started out, I remember after I passed the bar, it was 3 weeks before I was in my first med mal trial, and I was terrified, but it gave me great experience and really insight into really what it's going to take to represent people effectively. And again, the threat looming over whoever's involved in litigation, whether it's a corporate defendant, individual defendant, whoever it is, or a plaintiff, the threat to actually go to trial is what really drives a lot of the values and a lot of the decisions for the case. And so we have found that if we're always preparing for trial and working up cases as if they're going to trial without question, we're really prepared mentally, and we're prepared the case for trial, and that ends up being best for the client. So that's really the genesis of why we structured it the way we did.
And is that still the case today? As far as a new client, new case comes through the door, you're preparing that claim or case as if it's going to trial from
I think we have to. We do, and I think every lawyer should. It is not a day that goes by that I don't talk to a new client, and I have to set the expectations. All lawyers should be doing this. They always ask, what's it worth and how long is it going to take? And that's infected by some of the marketing culture out there that we're having to deal with. But sitting down with clients and say, look, it could settle, but I'm going to tell you, these types of cases rarely do. And so you need to prepare yourself. This is going to take X number of years, and we're going to trial. So we need to start thinking about that now. We need to talk about depositions. We need to talk about discovery, all those things on that initial interview, just so they get it in their mind. This is not going to be a 2-week, foray into justice. And so, I think it's absolutely necessary now. Even more so, you're starting to see verdicts across the country. For whatever reason, people all have their theories, but we're seeing an increasing number of plaintiffs' verdicts with increasing values, which I think are consistent with the injuries and the harm that's been done to some of these folks, but we're seeing it across the country.
Interesting. So do you find yourself vetting a case up front if you don't think a client might have the appetite or the patience for a situation where a case is going to require trial? Is that something you kind of will maybe refer someone to another firm on?
Absolutely. I mean, if we look at a client or we're talking to a client, and there are a couple things, and most lawyers will experience this. There's a client that won't present well in front of a jury, or maybe is exaggerating their injuries, or has outsized expectations of what the value of their case is. That does not ever sit well with an impartial jury of their peers. And so, absolutely, going into that first conversation, there is a decision in the back of my mind that has to be made. How is this person going to present to the jury? How am I going to get along with this client? If I'm preparing for trial and they're wanting to settle a case for pennies on the dollar, is it worth my time? And there are lots of lawyers out there who will like to take that case and sell it for 50 cents on the dollar. And if that's what the client wants, that's what the client wants, and they are the boss of the case. So that's fine, and I will refer that case out. But yeah, it is always in the back of your mind what you're going to be dealing with if this client goes to trial, how you get them there, how you shepherd them through the process, and what their attitude is going to be throughout the process. It's very important for us.
So, do you have any sort of cases that you don't file for litigation on? I know I talked to a number of attorneys, and in my own practice, there were a handful that we wouldn't even necessarily file litigation on. We'd obviously get the claim initiated and things like that, but a certain percentage of cases didn't actually get filed. Is that the case, or do you file all of your cases?
Usually, with the way our firm works, we don't have a lot of off the street walk-ins. We're getting a little bit better about that with, again, how the legal landscape is changing with marketing and everything else out there. But for years, our firm was the one that we were referred to harder cases, the ones that had been tried to settle, weren't going to settle. They come to us, or we mentioned at the front end of this podcast, we do a lot of medical negligence. Those cases don't settle in this state. I wish they did. I'd be a lot happier and have a lot more hair. So I always file the med mal cases. That doesn't mean I file every case that's presented to me. Now, we turn down 95% of them. If there's a case, there may be a commercial vehicle case that comes in, and the client would like an opportunity to try and resolve that case before filing suit. And again, they're the boss. Keep that in mind. There are a lot of things I'd like to do, but if the client doesn't want to do it, we can't. So yeah, we'll try and settle some of these cases, but ultimately or rarely do they actually settle anymore. And so that again goes back to, you've always got to be preparing yourself for trial. If the client wants to take a lot less money for a case that has a lot of value, try and talk to them reasonably about it, what they're leaving on the table. But I'm not walking in their shoes. I don't have the problems that they have. I don't have the need for money that they may need it for. And so I have to listen to them. Again, they are the boss. Yeah, to answer your question, probably 85% of the cases that I work on now are filed cases.
Erik, you're deeply involved in teaching trial advocacy, both nationally with AAJ and locally through things like your annual closing argument competition at Cumberland. What are you seeing in terms of the gap between what law schools are producing and what actually works in the courtroom?
Gosh, Adam, that's a really interesting question. I've not thought about that. I have a lot of opinions on that, but I've never really been asked that question. I think there's a huge gap. I think it's an enormous gap for a number of reasons, and some of them are not law school's fault. I think trial practice is a dwindling skill. At least where I practice a lot, it's 3 to 5 years to get to trial. In federal courts, I think the statistics are staggering. Only maybe 5% of cases go to trial. I think here in Alabama, it may be even worse or even a lower number. So, one, law schools, in my opinion, aren't preparing students for trial work because those students aren't seeing trial work once they get out. What's the demand? If the law schools are trying to prepare the majority of lawyers for what they're going to see, I can understand why they're not pushing trial advocacy programs and those kind of things. And then even more so, once they get out, they don't have the opportunity. You got older lawyers like me who may be control freaks. Lawyers have that reputation, and so they don't want to just hand over a case that's going to trial to a junior lawyer. I think we do a little bit better job here, but I think that's an issue out there. So to answer your question a little bit more specifically, I don't think law school is getting lawyers prepared for trial. I think there are programs that you can do on the side or as extra, which obviously takes away from time from studying, so there's not much of an incentive there. But then the reason that we're so involved in it is because it is a dwindling skill and the opportunities are fewer. But there's a a lot of good students out there that do great work on their feet. And so I've seen the generation that's below us that's coming up, they've got some really skilled advocates. So you just give them an opportunity to stand up and get what it feels like to be in an unstructured environment like a closing argument competition where they have to deliver an argument in a short period of time and be very persuasive. Just giving those people the opportunity to stand up and try those skills, I think it's invaluable. And so that's one of the reasons we do that. And that's a very small answer, a very small section of what we do to try and advance the advocacy positions in this state.
What are you doing to sort of train some of the younger associates to figure out how to think on their feet and be prepared to try a case while still kind of maintaining the control and direction over the case?
So what we do here is if there's an opportunity for one of our lawyers or one of our law clerks to get out there, present something on their feet, it could be talking on a podcast. It could be talking to somebody like you, Adam. It could be going to an advocacy program where you're not just sitting in a chair taking notes and watching people. You're actually getting on your feet. You're getting a lecture in the morning. You're actually practicing in the afternoon. It may be just sending them to the courthouse to watch some senior lawyers. When you talk about specific cases, almost every file in this law firm has two lawyers on it. And the primary reason is I want them going to court. I want them up on their feet, even if it's just a status conference. What's this case about? What are we doing? Where are we? Being there gives them an opportunity to talk in front of people. And then in trial, I will sit with them, or one of our senior partners will sit with them. They're always assigned some portion of it, whether it's voir dire, opening, direct cross. We have two closings here in Alabama, so the second chair, so to speak, is always going to get part of a close. That's what we've done to try and ensure that our folks are at least exposed to the trial process early on. And it's when I say early, it's kind of like what happened to me. It may or may not work, and it may push some people away, but once you're here, and you're in the well, and you're working, and it's trial by fire. And so I think that's the best way to do it. I think, if you look at some defense firms, they have a different approach. There's more risk there for them, but at least on the plaintiff side, I feel like we have the opportunity and the responsibility to train these people up. So that's what we do here.
When you were serving as president of the Alabama Association of Justice, one thing you said about that role was it's the Seventh Amendment, the right to a trial by jury that serves as the backstop for all other rights we hold dear. That's a strong framing. What prompted that emphasis, and what were you trying to protect or advance during your presidency?
Well, it's not just my presidency. So the Alabama Association for Justice is the old Trial Lawyers Association. It's just trial lawyers. And what we have seen consistently in our history is lawmakers by mistake or desire trying to remove the opportunity for folks to have their claims and cases heard by a jury. And it could be extending immunity, it could be extending arbitration, it could be removing claims, it could be putting handcuffs on people with disabilities about how they can try their case or whether they can try their case. So that's the frame that we were looking at. We were always there trying to protect the Seventh Amendment. People have an opportunity to have their case heard. It is a strong position, but you look at the First Amendment or Second Amendment. I mean, gun ownership is pretty important in this country. Why isn't the right to trial by jury? It's an amendment just like the second. Free speech, pretty important. Freedom of religion, pretty important. So I equate all of them equally. There's not one that's more important than the other. And so for all these years, we've wanted to have a trial by jury by our peers, then we need to protect that. And there's a lot of other reasons why, and transparency, or to be transparent, I would rather try a case to a jury than to an arbitrator. It's just more fair. There's more pressure. There's less bias. At least what I see on my side. That's the goal. That's going to be the goal for every president of ALAJ or probably any trial lawyer association throughout the country, because it's an important issue that we're trying to protect. And it's not, I think it's easy to say, oh, this is out of greed. Plaintiffs' lawyers just want to make more money, or they want to be able to sue more defendants. That's not really it at all. Because if people are behaving right and doing what they're supposed to do, they're probably pretty safe. But there's always those companies out there that are trying to cut corners and exposing people to real injury and harm. And that's the backstop. People don't care about getting a slap on the wrist, but when you start taking money out of their pocket, that's when it becomes a real issue. And so we've seen consistently that's where real change occurs, whether it's in how surgeries are performed, whether that's in how regulations are enforced, or backup cameras, or the backup beeps on these commercial vehicles. Those were born out of safety issues that resulted from trial lawyers' work. And so I think what we do is important, and protecting the opportunity is really important as well.
Now, looking at your practice specifically, you focus heavily on catastrophic injuries, severe brain and spine damage, trucking collisions, sexual abuse cases. These are some of the most emotionally and technically complex cases to litigate. How do you balance the compassion side of representing someone whose life has been, quite frankly, shattered with this injury? How do you balance that with the strategic and aggressive courtroom work required to win a case?
Oh, that's a good question. Balancing those, the compassion and the aggressive nature, is probably pretty easy in a medical negligence case or TBI case, um, commercial vehicle case, because you can talk to the client and they can see and understand the path. I've intentionally excluded from that the sexual abuse cases. Those are really emotionally fraught cases, really vulnerable clients, huge trust issues there. You get into the human trafficking sphere and you've got a lot of other legal issues that have to be navigated. So those are really big challenges, and we have to be careful, honestly, not to take too many of those and make sure the case is sound, because those clients need a lot of emotional support. And it is difficult. There's a little bit of a different mindset when you're working in those cases. A lot of hand holding, which is probably needed and required. So that's a unique sect. TBI cases are a little bit different. You need to make sure that there's a communication there. Sometimes you have clients that maybe don't understand or don't remember what we're talking about or what the theory is. So that's a little bit more complicated. But really, it's knowing that you're doing the right thing for the right reasons makes it a lot easier. I would be remiss if I didn't say I have an incredible staff here that makes my job a lot easier. A lot of good lawyers that are compassionate by nature. It's not something I've had to inject in them, and we screen for that to make sure that they have the right temperament for this. And I've had people walking them off say, I can't do the sexual abuse cases anymore. It is just too draining for me. And so I appreciate the candor. But overall, the staff recognizing what you're facing, what you're going to face in this litigation, make sure you have the right client for what you're trying to do, and be honest with them and set the expectations early. Those are the types of things that have made my life a little more simpler. It doesn't make the case any simpler, but it's made it easier to work with the people that I want to be working with, again, for the right.
That's a good answer. So you said you're more selective with the sexual abuse cases. What specific type of things are you looking for? Is it kind of temperament of the client? Is it the nature of the injuries? What type of things that are going to cause you to not take on that type of case versus one you will take?
Well, I think one of the things that we're always looking at is the client. What is the temperament? What is the expectation? Lawyers all remember the client that comes in and says it's not about the money, and that's a pretty good indication that it's about the money. What is the client wanting to accomplish with this? What can I prove? I get a lot of calls about, rape cases that I can't prove. I mean, I can't prove something happened. I can't prove something didn't happen. I can't prove somebody did something wrong. I got to be careful there. And honestly, the defendant, who are we going after? Again, this goes back to the expectations of the client. If they're wanting to sue their uncle who has been in jail for 15 years, and they're wanting to sue them for $10 million, there's not much I can do to help them there. And I have to be honest with you that you were you were harmed. You were abused, you were molested, whatever it is. But I need you to understand, you're going to go through this. You're going to relive a lot of this through what we're going to have to go through, and there's going to be an empty pot at the end. And I don't want to put you through that. And most of the time, people understand that and appreciate the honesty. But it's a challenge. And so there's a lot of things. Some of them are gut feelings, and there's just is anecdotal why I take it or I don't take it. But a lot of it rests on the things that most of us go through when we're evaluating cases, whether we think we're going to be able to be successful and give this client a good result.
You've been involved with the bar commissioner since 2015, excuse me, and you sit on the character and fitness committee and the disciplinary rules and enforcement committee. That's a window into the profession from a governance agent, from a governance angle. What are you seeing in terms of like where the profession needs to tighten up, whether it's ethics, competency, or something else?
Well, as we're recording this, I'm no longer a commissioner. You're capped at 9 years, and so my term expired, but you were absolutely right. It does open your eyes to the governance of the profession. And I've spent a lot of time on the grievance committee at a local bar, so I'm seeing most of the common complaints that you're seeing from clients against lawyers. I think there are competency issues for sure. Hopefully, the bar exams weed the I can't say they're the less competent out. If you can't pass the bar, you probably shouldn't be practicing law. So there is that. I think we're seeing lawyers getting squeezed with the types of cases that they can handle, and so maybe they're having a bad month or a bad year. So maybe I extend myself into an area of the law that I don't have experience in, and I don't really have a mentor, but I've heard you can make a little bit of money. That'd be kind of like me going out and trying to try a criminal case. I should not be in the courtroom in a criminal case. I don't know the law. And so people will get in there and try and turn the case or plea out when maybe they shouldn't, or they don't really understand things for a quick buck. I see it a lot in a divorce. Maybe I should go represent this couple in a divorce, or this individual in a divorce, and I get paid $6, $7, $8,000, but the case isn't moved along very far, and the client's now upset, and now they're contacting the bar. Communication is a huge issue. I think it goes back to what we just talked about. Maybe this is not an area that the client should have hired this lawyer for, or maybe the attorney's overworked, has taken on too many cases and can't communicate with the client, or it just doesn't want to communicate with the client. That's another thing you think about when you're taking a case. Is this somebody I want to be talking to on a frequent basis? If not, you probably just don't want to be there. It's a recipe for a disaster. So those are the big issues. I think lawyers getting a little overextended, and communication is just usually a huge issue. And I think you can say that about, our firm, but there's just communications everywhere. But, that's what I saw most in bar commissioner work and the grievance committee stuff that I did on.
So how do you guys at HGD make sure that those type of issues don't become the reality for your clients?
So from a competency standpoint, we're constantly meeting with each other, with the lawyers in our firm. We're constantly sending folks out, whether it's the CLEs, not because it's required, but because they do need to learn. What's the next stage? How do you use AI in court right now? That's something that we're struggling with right now, struggling with trying to understand and fully implement. From the extension standpoint, you're not going to see anybody here in a criminal courthouse. You're not going to see anybody here doing a divorce. We're not going to do a property line dispute. We're not going to draft a will. We know what we do. We're going to do that well. We're going to stay in our wheelhouse. The communication piece is challenging, and we've actually started something about 3 years ago. We call it our white glove approach to clients, and it's serious. We've got KPIs, key performance indicators, that have to be met every month about how you communicate with clients, what you communicate to the clients, and how frequently you communicate with them. We've had a lot of traction on that. Staff is really engaged in that. The lawyers are getting there, but it's a change of mindset. And so those are just 3 examples of what we're doing, try and keep ourselves at the forefront of what's coming, and making sure that we are taking care of the people who take care of us. If we don't have any clients that are happy, we're not going to be happy. We're not going to have much money. So taking care of the clients is the most important thing. Everybody says it. I'm very confident that not everybody does it. And so that's how we try to separate ourselves. It's like I said, it's a new effort by us in the past 3 or 4 years to really focus on that. And it's turned out well. I'm pleased with where we're headed.
Well, that's good to hear. You mentioned AI kind of in courtrooms, and you're looking at that and implementing that. What type of things have you guys kind of rolled out or tried to implement with either using AI or not using AI? What is your firm doing with regard to kind of the AI wave that's coming?
Adam, that's a $1 million question. It's so expansive, and there are so many applications. It's hard to wrap your head around and continue trying to figure out how to work your cases. It does so much, and there's so many potentials there. We'll probably just scratch the surface from what some folks are really doing on the cutting edge, but we could use it for intake. We do use it for intake, making sure that we get the details that we need to have, making sure that when the clients call, the phones are answered, and they'll just keep ringing. So AI has been helpful there. We've used it in document review, a closed loop system where you can try to make sure you're hitting what we need to hit when we're reviewing medical records. We're looking at different platforms about chronologies and, consistent communications with client. We already do that, use AI for that. So every month there's something that's going out. Even if the client hadn't called in 6 months, they're getting an update. There's some lawyers out there doing some really interesting stuff on focus groups, and we've used AI to really focus group some cases in a unique way, and it's been pretty accurate. It's been really helpful for us, and so that kind of gives us an idea of what a likely juror is to think about. And it's weird to say that it's been accurate, but in hindsight and in doing real live focus groups, AI, if you do it right, you prompt it right, you get some real insights there. So that way, um, gosh, there's probably a dozen other ways that we use it internally on some marketing pieces, and just making sure that what we push out is consistent with our values, and what we want to represent to the public and what we value inside the four walls of this office. Those kind of things. Writing, I mean, it just goes on and on and on. I mean, I'm probably just giving you 5 or 10 of the ways we've done it 20 different ways.
Got it. You mentioned the white glove approach or white glove initiative that you guys started 3 years ago. What are some of the kind of the KPIs that you guys are tracking to make sure that your attorneys are doing what they can to provide that white glove service to the client and make sure the client's not going to be calling the bar association on your
Yeah,
attorneys?
right. Well, it is. So answer the calls. If you can't answer the live call, it's got to be returned within 24 hours. Consistent updates, and what's in those updates is not just, hey, your case is still going on. What's going on? Or what's happening the next month? Have there been things that have changed in your litigation? Has the law changed? We've had to update some folks on saying, hey, this case from the Supreme Court came out and we've got an issue we got to deal with. Those are a couple of the big ones. It's really just getting into the minds of our lawyers to import on them how important it is to answer that phone call. 10 years ago, my phone would be full of messages. And the people that pops up on screen, I don't want to talk to that person. But this has helped kind of change the frame of mind. Like, remember, they are the boss. They're the ones you're going to have to talk to them at some point if you want to resolve this case. If you're going to trial, they're going to have to be there. So having a good relationship with them is pretty important. But those are probably three of the most frequent KPIs that we see. And we've got some more that are probably a little bit deeper that need to be adjusted. But just having something out there where there is some sense of accountability is probably the biggest driver for us.
Erik, currently, what is your role in the day-to-day operations of the firm? Are you more kind of the trial lawyer that comes in and pushes the case to the jury trial? Are you taking on more of a managerial aspect? How do you fit in with the day-to-day aspect of the operations at the firm?
That's a good question. So it evolves what the firm needs at any given point. I think currently where I sit is I've got really good lawyers below me that I don't hand off a case, but I assign them responsibilities on the case, which is another way I stay involved. So they'll get the case, they'll do it the day-to-day work, making sure that discovery is being answered, make sure documents are being requested, make sure depositions are being set. But on big issues, they'll come to me, or we'll strategize how we're going to get from A to Z on a certain case. If it goes to trial, I'm there with them. Or if it's not a case that I want to be on, maybe somebody else needs a little bit more experience. Maybe someone needs some time in the courtroom. I'll assign another lawyer to go try that case with that individual. I'm not the managing partner. Quite frankly, I don't want to be the managing partner. I think my time's more valuable being out in the community, talking with people, meeting with lawyers, getting referrals, figuring out the strategy going forward for the next 5 or 10 years. That's where my time is spent right now. I've got other lawyers that do a great job managing the firm. I've got other senior partners that are completely focused on trial. That's all they want to do. And that's great. My interests are a little varied right now. And so I'm probably more like your Swiss Army knife right now. I do what needs to be done at the given moment. But my favorite parts are the marketing aspect, talking to clients and trying cases. So if I could limit myself to those three things, I'd be a happy man.
Very good. So you mentioned kind of the forward trajectory of the firm. Where do you see the firm going, or what is the plan for the next 2 to 5 years to 10 years down the line? Are there any big initiatives or changes or anything you're looking forward to on the horizon?
Yeah, I think what we've done specifically is we've really, I said earlier in the podcast that traditionally we are a referral law firm. We get a lot of cases from other lawyers that don't want to try the case. And that's changed dramatically here in the last 12 months. We've probably got 7 or 8 different funnels where cases are coming from. So we've got a foundation so that we're not having to jump on TV, or we're not having to go buy a bunch of billboards. We're good with the funnels right now, and I'm happy with that. And that could change tomorrow, quite frankly. So you got to stay up on that. But So I'm comfortable where we're headed. We've got a mass tort division and a class action division too. I would be remiss if I didn't say I'm a little concerned about mass torts and where it's headed. I just don't know, and that's something we've got to really watch out for. There's nothing out there that's really got a lot of traction from a financial standpoint and an evidence-based claim that we're working on. We've got a lot of projects, but there's not that signature one out there, and so I don't know where that's headed in the next 2 to 5 years, and what that's going to look like. Class action's okay. We're good. We got a lot of different cases on that front. So it's just kind of making sure, or the goal is to make sure that we're solid. And I think right now for the next 2 to 5 years we are. We need to hire some lawyers. We need to get our backbench solidified. We've got some aging partners that are probably sliding away pretty soon here, and then we've got a great middle, but our young lawyer core is not very strong. We need to really build that up. Those are the things that I'm really focused on. And, I think we have to mention technology. I have no idea where AI is going to take us or where we're going to be next year. So trying to position ourselves so we're okay and are implementing it the way it needs to be done and doing it the right way and just keep it up. So that keeps me busy. I guess the state legislature could cancel all or adopt tort reform and I'm looking for another job somewhere. That could happen too, but I think we're in a good shape right now.
Good. How many attorneys do you guys have now at the firm?
We've got 15.
15. Very good. And last question here. So you just earned your third Lawyer of the Year recognition from best lawyers in medical malpractice. That's a rare streak. What's evolved in your approach to these cases, the medical malpractice cases over the last few years, that you think is driving that peer recognition?
I wish I could say that it's skill or success. I don't know that it is. It may just be stick-to-itiveness, I guess, maybe. No, but I think it's unique in the market that I'm in. Quite frankly, there's not a lot of lawyers doing medical malpractice. I will say the ones that are doing it are damn fine lawyers. And so it's not just me out there. There's some really good lawyers doing really good work. It's been an evolution for me, trying to figure out what cases actually work and what juries actually get concerned about. Staying within those guideposts. I find whenever I get outside of that, that's usually when I don't do well. But if I stick to my experience and what's worked, we have good success. Ego always kind of gets stuck in there and makes you think you can do something that you probably can't. And it's a good reminder to go down to the courthouse and 12 folks tell you that you're an idiot and you're gonna lose. That'll remind you real quick. So I guess it's that. It's the experience and it's the mentorship. I mean, I've worked with my dad now for almost 20 years, and he loves those cases. He loves them because they go to trial. He'll take the ones outside the guidepost almost intentionally so he can go to trial. So that's helped a little bit in a painful way because it's shown us repeatedly, these are the kind of cases you'll have success with, and these are the ones you won't. The experience, picking the right case, having the right defendant, having the right approach. And I guess I would say also part of the reason that I've gotten that award, I think, is professionalism. I'm not the guy out there that is railroading the defense lawyer or berating the defendant. Coming in respectful, understanding the rules, using the rules where I can use them, and not pushing frivolous claims is pretty important. So I think that professionalism, the civility, is really important. I think it's something that our profession is lacking, and it's getting worse instead of getting better. And so I think that award reflects at least the opinion of some of my peers. I hope it does. Otherwise, I probably wouldn't have gotten it. But you know, those are the reasons I think I got it. But it could be that nobody else voted. I mean, who knows?
Yeah, that's interesting. You think it's getting worse instead of better as far as ethics and things like that. Do you have any reasons or hints or guesses as to why that might be, or is it just the younger generation, or
Well,
what do you attribute that to?
I think everybody's being squeezed. So I think you've got some lawyers out there that really are struggling. And so they feel that they've got to get as much juice out of this orange as they can. And so they're willing to go a little bit beyond what's reasonable. Defense lawyers too. I mean, they have to make a living. And, they're getting squeezed by their clients or their insurance companies. And they got to do X, Y, and Z, and they can't do anything until they do X, Y, or Z. just understanding the other person and what they're probably going through. I think sometimes we get on our high horse thinking that we've got the best case in the world, the best client in the world, and we're going to win $100 million. And that's not true. It's just so rare. And trying to go into every case saying that, you lose a lot of credibility. So being honest, I think people are less than honest sometimes, try and get an advantage, and you start losing trust. And then we're just not around each other anymore. When I started practicing law, I kind of sound like the old man saying, get off my lawn. But there were a lot more opportunities for lawyers to get together. There would be these, I would call them cattle calls. You'd go into the courthouse and they're on the docket. It's just a status conference, but there'd be 100 lawyers in there. And I heard a line the other day, which was helpful to me. It's hard to hate close up. So, I mean, if you're with somebody, if you have an issue, call the other lawyer. Don't fire off a motion to the court. I think we're seeing that more too. And just a reluctance to pick up the phone. And it's amazing how many things get resolved very quickly just by calling somebody or going to have coffee with somebody or having lunch with somebody on the other side. I mean, how crazy does that sound today? Like, you got a defense lawyer, you're gonna go have lunch with him and talk about the case? That's insane. Why would you ever do that? But my experience is it gets results. And the next maybe we don't agree, but the next case, we'll go to lunch and he or she buys, and all of a sudden we find places that we can agree on. I'll give you a perfect example. There's a case that I just filed. It's a nursing home case going to arbitration, and the agreement called for using this group that's just awful. They're expensive. They're slow. And so I just called the lawyer and said, hey, I'll agree to go to arbitration. Can we agree not to use this group? She's like, yeah, that sounds like a good idea. They'll save money. I'll save time. Everybody wins. And those things don't happen unless you have some trust and credibility and are respectful to the other side. And I think that's just getting lost these days.
That's a great answer, and I think you're spot on with that. Erik, thanks so much for joining us today. Where can our listeners find out more about you and your firm?
Yeah, so Heninger Garrison Davis, we're in Birmingham practice, but I would probably say I'm more regional, so Southeast. Website is hgdlawfirm.com. I think I'm on Instagram. I think I'm on YouTube. I got somebody who does that for me. I don't understand social media very much. So any place, just my name as it's spelled there and pronounced. It's vinegar with an H, so it's Heninger. So it's pretty easy to remember, right?
Thanks so much for joining us today.
I appreciate it, Adam.